morning. Does everyone see my screen? Perfect. Okay. Our presenters today are Christine Ameye and Amanda Madden. Christine, would you mind going first and telling us just a little bit about yourself for those in the room that don't know who you are?
Sure. Good morning, everyone. My name is Christine Ameye. I joined Titleocity a little over a year and a half ago. Best decision I ever made. I've been in the business probably, I would say this is my 25th year of working in title. So I've just kind of aged myself, but that's okay. I love doing it. I love helping people. I love figuring out problems. And basically, I'm just here to support you and answer questions and get you to the closing table and figure out all our problems.
Thank you, Christine. Christine is absolutely fabulous. So if you ever have any questions, I mean, she will answer them to the T and figure out a solution for you. Amanda Madden, I saw you, but you're not showing on my peeps right here. Oh, I see you. I had to scroll down. Amanda, if you wouldn't mind as well, just giving us a short introduction of who you are. Thanks.
Yeah. Hi, good morning, everybody. Thank you so much for joining us. Real quick, my phone number is wrong on this first page, just sidebar, little house cleaning. So the 353, it's actually 6871. So we'll fix that, Sarah, but just so everybody knows, most people have my direct cell phone number, but it is 353-6871. So my name's Amanda. I've been in the business, I don't know, 23, 24 years, very similar to Christine. Love all things title. Love Titleocity. One of my favorite presentations for us to do is the Title 101. I think that it's something that every agent kind of needs to know a little bit about, so many different parts of this business. As an agent, you've got 17 hats. You've got to know a little bit about title, a little about the lending, the appraising, all the different bits. So we're just happy to be here and support in any way we can.
Awesome. Thank you. Okay, so we're going to go ahead and get started. I am going to get us onto the next screen here. Amanda, I believe, or Christine, can you lead us off, please? Thank you so much. You are muted.
Okay, so let's start from the beginning. So we're selling, buying a house, refinancing, and we need to order title insurance. So the first thing we want to do is contact the title company and present them with the property address and all of the necessary information that the title company is going to need to search the property and get the file in motion. So title is very important. A chain of title represents the transfer of ownership all the way back from when the property was created. Okay, so a chain of title can be a quick claim deed, a warranty deed, a fiduciary deed, a covenant deed. There's a lot of ways to transfer title. We prefer a warranty deed. So what we do is, as the title department, is the order comes in, purchase agreement, refinance information, whatever is necessary. And the abstractor gets the file and they search the public county records for all of the chain of transfers and any liens that are still open on the subject property. Any kind of defects that we can find, we want to cure before we get to the closing table. So what we do is we compile all those documents. They're presented to the examiner. The examiner goes through all of those documents and decides what is necessary to be done in order to transfer clear title or to ensure a lien position. Once the examiner makes those decisions, they put it in commitment format. Commitment format comes in the form of Schedule A, which shows you the effective date at the county. The effective date at the county is the county certification date of when they have gotten all of the documents they've received up to that date recorded. And so that the effective date is in essence what the date we can see what has occurred on the property up to. So your Schedule A is your effective date, your amount of insurance. So say if your sales price is $100,000, you will see that on Schedule A. And you will also see two more important parts on Schedule A. And that is the current vesting of the property, which means who owns the property and how they hold title to it, along with the legal description of the property. One of the misconceptions is that a title company insures by address. We do not insure by address. We insure the actual description of the property, whether it's a lot in a subdivision, whether it's a unit in a condominium, whether it's a meets and bounds description. That is actually what we are insuring, that description. So when you turn the page and you go to Schedule B1, which is requirements. These are the requirements that we have determined that are necessary to fulfill to get us to the closing table and issue clear title to the property. You can see a type of transfer, eliminating an interest, recording a discharge of a mortgage or lien, a state tax lien, federal tax lien, judgment lien. You can see numerous things on there. If the property is held in an estate, we'll ask for probate court to be initiated, copies of letters of authority. Any of those kinds of things are seen on Schedule B1 requirements. And it also gives you the tax information to the property. It gives you the current year's amounts and whether they've been paid or they still remain due. If they're due, we want to get those paid. So then when you flip the page over to Schedule B2, which is exceptions, these are exceptions to coverage. Typically on this page, you see easements of record, any kind of issues that come up on the plat, like, if there's a right of way or, if there's some common area around. Anything you see on the exceptions are excluded from coverage, are going to be excluded from coverage under your policy. So once you review the commitment, the processing department takes over. Oh, I'm sorry, Sheila. Okay. We'll go back. I'm just giving you a brief overview of what happens when you submit an order. So once that commitment is complete, it's turned over to our processing department, and our processing department then reaches out to any of the necessary parties that we need to gather more information from, or we need to, they need to assist us in fulfilling any of those requirements to get us to the table. Now, I'll circle back. So when you're placing an order, if it's a sale transaction, one of the most important documents is the purchase agreement. The purchase agreement dictates how the entire transaction is going to go. It's going to tell us what type of policy we're going to issue, what the legal description is that we're going to issue, sales price, the type of transaction, the buyer's name, the seller's name, all, the listing agent, the buyer's agent. It's going to give us all of that information. One of the key things I always like to say is knowledge, or information is power. So the more information we have, the better we can assist you and prepare a proper document for you from the get-go. Sometimes you don't have a purchase agreement and you've listed this property and you want to get ahead of the game. We love that too. We call it pre-title. So when you submit the information for pre-title, we need the property address and who you think the owner of the property is, and we can start from there. Like say you're going to go list a property and you're unsure if the person has the authority to sell the property. So we go ahead and run the pre-title so we can tell you who actually has authority to sell that property. And then you can figure out who you need to sign the listing agreement and so on and so forth. So the more information is key from the get-go, because if we don't have all the information from the beginning, it's almost like taking a bunch of puzzle pieces and putting it all together. But the more puzzle pieces we have to start, the more the puzzle is clearer. So that's why the information is important. What do we got on the now? Okay, who owns it? Yep. We went over the types of ways to own the property by, types of conveyances, warranty deed, quitclaim deeds, covenant deeds, just to name a few of them. And that is our responsibility when we abstract the chain of title to figure out who owns the property and how they came to that place. So there's several ways to hold title. Here's just some references on what each type of vesting means. You have tenants in common, joint tenancy with full rights to survivorship, and then tenancy by the entireties. And it gives a brief explanation as to what each one means and what it means in the event that, if you hold title, like, I'll give an example. If you hold title as joint tenants with full rights of survivorship with your brother, right? And unfortunately, one of you passes away. In that instance, the person who passes away's interest automatically goes to you because you held it jointly with survivorship with that person. Now, if you hold it as tenants in common, the person who passes away, their interest actually goes to their estate. So you still retain your portion, but however, their portion didn't get transferred to you. It now goes to their estate. So there's several ways to hold title. And those are very important. And we suggest that if you have questions on how you should hold title or are not clear on how you want to proceed, we suggest contacting an attorney, because an attorney can also give you a more in-depth look as to what each one involves and what it means to hold title that way. So we went over a broad overview of search and examination. Once again, it's just part of the title process, and it gives like a book report as to what's occurred on the property all the way from, you know, its inception. And that's our responsibility. That, you know, that's part of the insurer's responsibility, is to look at all of that information and present it and let everyone know what needs to be done to get to the closing table. So we do have underwriters. One of the things that sometimes isn't always clear is every title agent is underwritten by an underwriter or multiple underwriters. Ultimately, it's the agent's responsibility to perform under the guidelines of the underwriter has set for all of us. There are instances when we can turn to our underwriter for guidance and for opinions, but ultimately it falls on us to be responsible and follow their guidelines. So basically, we talked about the policy. Once the policy is issued, this tells you that there are no other interests remaining. You own the property free and clear. It ensures your lien position, saying we've eliminated anything that could compromise the mortgage on the property, and issued a first lien to the lender or the bank in that circumstance. We went over we did a broad overview of the title commitment, the Schedule A, Schedule B1 requirements, Schedule B2 exceptions. If you have any questions on reviewing these types of commitments, or what you see or what something means, you know, all of us are really educated and knowledgeable in anything. So just feel free to reach out. Send us an email
to you. But
I'm sorry.
We can definitely send these slides out to everybody as well,
Yeah.
just so that you have all of that in the breakdown.
Yes, and you can always reach out to us too. If you see, you know, a funky requirement on there and you're like, I've never seen that before, what does that mean? Send us an email, give us a call. We'll be glad to, you know, break it down for you so you have a better understanding. Because sometimes, you know, a lot of the requirements and exceptions look the same. You know, like they're pretty understandable, but then every now and then something unique pops up, and just reach out to us. We'll let you know. Eliminating defects. The defects can be anything that jeopardizes a lien position. Defects can be anything in the way of an interest that shows up, you know, that didn't get eliminated in the chain of title. Like, say, you know, a husband and wife owned the property and they got divorced, but only one of them deeded the property out. Well, what happened to the other person? We're going to find out. We're going to go back and we're going to say, hey, you know, can we record a copy of the divorce judgment? Can we get this person to deed off? That would be a defect in title, but it's our job to assist you in clearing those defects. The final title policy, we went over this. This is issued after closing, when all of the defects are cured and all of the necessary documents are executed. And the necessary documents are sent for recording at the county, giving constructive notice of their placement on the property. So I'll turn this over to Amanda here in a quick second. So after, like I said before, after the commitment is completed and turned over to the processing department, the processor will then reach out to the necessary parties to help cure any issues on the requirements and go from there. And that is where Amanda's expertise comes in. Just a part of her expertise comes in, but she's really good at that. So Amanda.
Hey, okay. So I want to talk about when it starts to get a little bit fun. Now, I'm not saying that Christine's part of the process is not fun, but title searching and title examination is so a behind the scenes part that a lot of agents just really don't ever get kind of a sneak peek behind. Typically, most agents are have a little bit of knowledge and a little bit of experience with what happens once the commitment is done. Basically, we've been giving our orders. We've been given the items that we need to clear in order to actually insure the property. So once the commitment's finished and Christine's team has prepared that commitment to insure, the processor is going to look at that. And basically what they're doing is breaking it down into layman's terms, right? So reading a title commitment is something that you get better at over time. I think that it looks very confusing. Sometimes there's things you really just don't need to pay attention to, but those things are lumped in with the important stuff we do need to pay attention to. So reading a title commitment, we've done classes on or sessions on just that subject alone, right? Because it's that important. Knowing how to read a title commitment is valuable, and if you're interested, we could probably do a one-on-one session with you, or we could send you some materials if you're interested in knowing more about that. So once we get the commitment, we're looking at the requirements page. So the processor who you're working with is going to kind of break down what is it we need to do in order to get to the closing table. And that's everyone's favorite part. That's the goal. At this point, you've probably been working on this file or working with these clients for weeks, it could be weeks, right? So the processor is going to reach out to the agent and say, I would like to request a payoff authorization. I would like to request the contact information for the HOA company. Again, they're going to look back to those requirements and see what liens or encumbrances are showing that we need to get cleared up so we can transfer marketable title. As you're working with your processor, it should go pretty smoothly. They're going to ask you for some things. They might also ask to reach out to your client. If you have the seller, they might ask, just to make it a little bit easier, do you mind if I reach out to your client to request the documents needed? Once we get all of those documents, we're clear, if you will, on our, say, title side or the seller side. So if everything goes well, the payoff comes in, the HOA status letter comes in, and we're ready to go on the seller side. So the next part would be the clear to close, which is everyone's, favorite words in a transaction, right? We're clear to close, meaning go ahead, agents, go ahead and set the closing. So once that closing is scheduled, okay, at that point, the file is going to be passed off from our processor who's worked on the file since the purchase agreement came in. That's going to be passed off to an escrow officer. That escrow officer, if we're handling the seller side, meaning you're the listing agent, you're representing the seller, we're insuring the owner's policy in that instance, and we're handling the seller side of the transaction, it's going to be our responsibility to produce the real estate documents. Most importantly, the ALTA closing statements. So those ALTA closing statements are going to include the sales price, tax prorations, earnest money as a credit, anything that needs to be paid, any charges from either the title company or the commissions, compliance fees, mortgage payoffs, and it's going to show what that seller's bottom line number is going to be. So those ALTA closing statements will typically come first. Usually, most title companies will send those ALTA closing statements out to the agents for review. And the idea being, hey, take a look, make sure we have the sales amount correct, make sure we have the commissions correct. Things like that. That's not to say it's the agent's responsibility to double check, but there are times where we get to the point of it's clear to close, we issue statements, and then we find out, oh, the sales price changed and maybe we didn't receive the addendum. Or we do the statements and there's occupancy that was originally agreed to. And when we send the statements for review, we find out they agreed to give keys at the table. So there are things on those statements, in addition to the commission amounts, that you want to just take a peek at. And I would encourage you, when you receive those statements, to reach out to your escrow officer who sent them, if you want to kind of have a quick review. Any one of our escrow officers would be more than happy to jump on and take a look at the statement with you, kind of go through it, answer any questions that you have, so that you then are in a better position to explain and present that document to your seller. Also, always an option that any one of us here would be willing to also go over that statement with your seller if you felt more comfortable or if they had further questions. So once those statements look good, we're moving towards the closing. What I want to say about closing and scheduling a closing is 2 days is really kind of what we think should be the minimum. That doesn't always happen, and that's okay. We scheduled one, I think, yesterday for today. Sometimes that happens where for various reasons, it's up on contract and someone's leaving on vacation or something happens that we have to push it through a bit faster. But just so you're aware, 2 days would be what we would prefer be the minimum. And of course, a little bit more time is better. And the reason I say that, I think that that's a point of pain or a point of frustration sometimes for agents, because they just don't understand the background and the behind the scenes that has to go on in order to prepare for a closing. And just like anything else, if you're rushing something through and kind of, there's more opportunity for error or mistakes. So allowing a little bit of time, if possible, 2 or 3 days in advance of scheduling a closing is always going to be your best bet. Also, another thing I want to mention is, and we've got an extra piece of material that we'll send out to you as well. I'm thinking of the wheel, Sarah. We'll just make sure we send the wheel when we send this screenshot, but knowing, I can
pull it up really quick too.
Yeah, that'd be great. Knowing what side you're on, meaning if I'm representing the seller, this is what I should expect to happen or the next step should be, or if I'm representing the buyer, this is what I should expect to happen or who I'm receiving information from. So that's an important piece as well. So again, we're moving towards closing. We've got our statements out. We've produced the real estate package. If you are representing the buyer, okay, in this scenario, and say you've got both sides, right? You've got both. Double dipping is our favorite. Well, my favorite. I think it's great. So you've got the buyer as well. Say, for example, once those real estate closing statements have been produced and we've received the lender's closing instructions, now we're ready to go ahead and prepare that closing disclosure or CD for the lender. So with that information, with the lender's closing instructions, we prepare the CD and we send that out to the lender for review and approval. Now, that can take some time as well. This is kind of my point to go back to say, having a few days is really nice, because sending a CD to a lender is not an instantaneous approval. Sometimes there are things that they would like for us to change, maybe even changing from what their original instructions were. And so there can be a little bit of back and forth with that lender to get that CD just right. Keeping in mind, there are rules and regulations about what things can change from the initial disclosure. So the lender is going to make sure that they have the numbers exactly correct and we match those numbers. Once the lender has approved that closing disclosure, then we are able to go ahead and send out the final ALTA statement. Now, a combined final ALTA statement is going to show those same seller numbers that we provided when we initially sent the statements. It's also going to show all of the buyer's fees and charges. That's real estate charges and the lender's charges, okay? So it's going to give a bottom line of what the seller is going to receive at closing, hopefully they don't have to bring money. That's always the worst. And then what the buyer actually has to bring to the closing table. Now, I want to say that even though the title company, once that CD has been approved, even though we're sending out that final combined ALTA to kind of say, here's the final numbers, it really is the responsibility of the lender to communicate that bottom line to the buyer. So we get this question a lot where an agent will call, say the closing's tomorrow morning at 9 a.m. Agent calls, it's 3 PM and they're in a panic. And they say, my buyer doesn't have their numbers. What's the final number? Why doesn't my buyer have their final numbers? My first question is, especially if I know we have an approved CD, is, well, did the lender not reach out? Okay. I think we're seeing almost more, and I don't know if anybody has any experience with this, and if you guys want to chime in or we can talk about it after, but we're seeing more and more that lenders don't seem to always be necessarily communicating that number. And I think maybe because of the splits that we've been dealing with over the last year and a half, maybe because it's the pandemic, I don't know. But it seems like more and more we're being asked to provide that final number, which we're happy to do so, but just know that when you're representing a buyer, it really is the responsibility of the lender to go over all of those closing fees, origination charges, you know, the holdbacks, you know, impounds, escrows, things like that. That stuff we can explain, we can walk someone through that, but it really should be coming from the lender. Another quick thing about that, we get this sometimes too, where you know, we can only send a copy of that closing disclosure to the buyer. We're not able to, because of, you know, rules and you know, regulations, we're unable to provide a copy of that closing disclosure or the mortgage package to anyone other than the buyer. So at times we will have an agent call and say, you know, I need you to send me my buyer's mortgage package. Well, we can't do that. Okay. So we've got an approved CD and we're ready to go to the table. Basically, if everyone's in the same room, which rarely happens anymore, it used to be back in the day that everyone showed up at the same table at the same time, typically at the title company, and that's super rare anymore. We had a closing here at our Troy office the other day, and we had 2 sellers, 2 buyers, 2 agents, and a loan officer, and it just felt like Christmas or something. I'm like, this is great. This is everybody here at the same table. It makes for a really smooth closing when you have everyone together. So many things can just be kind of worked out and settled right there at the table versus having to go back and forth, wait for, you know, a response or wait for documents to be exchanged. I know that's not always a possibility, but when you can arrange the closing, you know, to have everyone together, it's nice. There's definitely a benefit to that.
Hey, Amanda,
Yeah,
super quick. I was just gonna say that was one thing that I had to get used to, you know, since COVID, you know, the non-traditional closings, which now seem like they're traditional, where we're closing buyers and sellers different times.
Yeah.
So that extra 24 hours to get the package to where it needs to go, you know, they have to be together in order to get funded. So
Yeah.
it was something I kind of had to, you know, visualize and understand the whole process and why it does take some extra time, you know, to get the disbursement and get the checks out and all of that. So thanks for going through that. Appreciate it.
That's a great point. Thank you. And that gave me another thought. That's something worth mentioning is, again, we have this happen occasionally, where, you know, if we have a true split, and really feel free to reach out to us and contact your escrow officer, contact myself, contact your agent advocate. We can help you kind of talk through what makes the most sense when you are trying to coordinate a true split, because it can be confusing. We do run into situations where the seller says, so for example, you represent the seller and the seller says, I have to sign at 9 a.m. That's it, my schedule, I have to sign at 9 a.m. And fine, 9 a.m. So you schedule with us for 9 a.m. for the seller. The buyer, they've got a schedule to keep as well, right? So they're going to sign at 4 p.m., right? If you know that your seller is adamant that they need to receive proceeds that day, or sometimes we get those sellers that say, I'm not signing unless I know for sure I'm walking away with my proceeds. I'm taking a check at the table. If you know that, or if you know you have a seller that maybe just is a little bit particular, you know, a very analytical type thinking person, you know, it's really about managing the expectations of the client, right? So if you know that the seller's gonna want funds that day or at the table, but they're telling you they're signing at 9 and the buyer's signing at 4, at that point, we already know there's absolutely no way they're gonna get proceeds the same day, especially if it's a split closing, right? If we're representing the seller side, and ABC Title is representing the buyer's side and the buyer's signing at 4, they have to send us all of their documents. We would have already sent all of our documents to them. And then they have to get funding approval most times from the lender. And then they can send the wire out to the seller. Now, we all know that mortgage closings can be, you know, there's a lot of documents. It can take approximately an hour. And the Fed cuts off wires at 5. So my point in saying all of that is when you're scheduling a closing, regardless of your seller side or the buyer side, try to think about the dance of it all. Think about realistically who's going to be issuing the proceeds, which is always the buyer's title company. Buyer's title company, right? They're working with the lender, meaning the lender is going to send the loan amount funds. The buyer is going to send their funds. Now that buyer's title company is holding all of the money. They're holding the commission money. They're holding our fees. They're holding the proceeds. They're holding any payoffs, right? So when we have a true split, which is now just kind of the way, we want to just make sure we're at least putting a little bit of thought into what does my client expect to happen at the table? Which side are we on? And the timing of when is the seller signing? When is the buyer signing? If you want more information on that, or if you want to give me a call, please do. We can usually get creative and just try to talk it through to figure out what is the best course of action. You know, again, not to go too long because I tend to do that. Let's see. A lot of the times when we would get a request to say schedule for 9 in the morning, or we'd get a request for a 5 o'clock in the afternoon, I would say to the agent, absolutely, I'm more than happy to schedule that closing. However, have you thought about this? And it's not to challenge or question the agent at all. It's just to say, hey, I see that you've requested to schedule this buyer's mortgage closing for tomorrow at 9 a.m. I just want to give you a heads up that because the closing disclosure is just now going out today for approval, chances are that lender's wire is not going to be in by 9 a.m., right? So again, I think it's about managing expectations. If I say to that agent, hey, can you check with your buyer and see if maybe an 11 or a 12 o'clock would work? Because if we close a little bit later in the day, we increase our chances, we increase the likelihood that that lender's wire is going to actually come in. Okay, so again, just last week, somebody calls and they want to schedule for 9 in the morning, and I said we can do that. However, 9 in the morning is a rough time to close a mortgage, and they said, well, great, I'll talk to my agent or my client because they said anytime in the morning, right? So I think just asking the question of, hey, is it possible that we could maybe do it a little bit later, just so that everyone gets what they need in a reasonable time frame. And then real quick, I want to just talk about dispersing, and then I want to go kind of just through the wheel for 30 seconds. Once we get to the point of dispersing, meaning we've got all the signed documents, we're, say, for example, insuring both sides. You have the seller, maybe you also found the buyer, okay? And we're dispersing. Once we have all of the money from the lender, all the money from the buyer, and the lender has given us the funding approval, then we are able to disperse, meaning we're going to send all the checks out for either proceeds, commission. We're also going to send any mortgage payments or payoffs out. We're going to pay any taxes that we're owing on the property. We're going to pay any current water owing on the property. And at that point, we call it like wrapping a file. We're kind of wrapping up all those loose ends on that file so that we can issue the final policy. So real quick, before we go into any kind of Q&A, and I know I used a lot of words in a short amount of time, but the wheel in front of you right now is something that we kind of collaborated as a team and created a while back that I really love. And this is a perfect example, and I'm a visual learner, so I like the visual, but this is a perfect example of kind of the steps and the process of closing. So at the very top, the 12 o'clock position there is, I've got a purchase agreement. Awesome. You're under contract, your buyer got the property they wanted, everybody's happy. That's when the fun really starts, even though you've probably already been working for, again, several weeks possibly on this. So purchase agreements in hand. Again, title search and review. I'm pointing to my screen as if you guys are right in front of me. Title search and review, which is done by the title department, as Christine reviewed. Again, we're going to clear title. That next part, that third step, processor is working with you or with your seller to clear any interest and to gather the information necessary to close. That clear to close, again, those magic words, everybody's favorite words, which a lot of times we're told it's clear to close, and then it cancels and we find out, oh, it wasn't clear to close. It's like, well, I thought they said it was clear to close. Clear to close is an actual designation. It's not just words that are thrown around. It's actually, you're either clear to close or you are not clear to close. Almost clear to close is not clear to close. What's that saying about horseshoes? Anyway, once we're clear to close, that's kind of when again, it gets even more fun. Now we're kind of in second gear. You get copies of the closing documentation, the closing disclosures approved. Then we're at the table, we're closing. Again, we're getting funding. And then once that's all done, everything's been funded, all the checks have been dispersed. We're going to record those documents, always a deed, always it's going to be a warranty deed. If it's not a warranty deed, it's likely going to be a corporate deed or a fiduciary deed if we have somebody acting on behalf of an estate or something. Attorneys don't like to sign warranty deeds, so they'll usually do their own. So we're always recording a deed. If it's a mortgage deal, we're going to be recording that mortgage. Again, at times we're recording a death certificate. Like Christine had mentioned, we're recording possibly a judgment of divorce. We're recording possibly a certificate of trust if the property is held in a trust. So any number of documents can be recorded. Once we get all those recorded and we have confirmation from the county that everything's been put of public record correctly, then the file goes right back around to Christine's team again, and we're issuing that final policy. I think we have another one coming up soon about policies specifically, because that can be kind of we can go into a deeper dive on what each policy really means and what and who we're actually insuring. So I don't know that I have anything else necessarily, but if we want to go to questions, or if Christine, you have anything to add to that, or Dawn or Sarah.
I just want to say really quick, something that we're huge about here at Titleocity is education for our customers. And even if it's just like a tidbit, hey, we saw this week, here's what you should know. We do this thing called the Titleocity midweek title tip. So if you're not on our email campaign, please make sure to put yours in the chat box so that you can get on that. I mean, we send out stuff all the time that is just like a quick reminder, or we did some land contract things, we did some power of attorney things, just something to keep on hand, so that that you have this information in case you ever need to come back. And we're always there to answer your questions, but it's just keep a little Titleocity folder, and oh yeah, I remember they talked about this. So
yeah, the title tip weekly is actually really well thought out, and it's actually good to see that. It's friendly reminders, little tidbits you might not have known. So yeah, Sarah, good job at pointing that out. Definitely want to get on that list if you're not on it already. I have nothing to add. I love the wheel. The wheel's like so awesome. So it really gives a clear cut, step by step with a little explanation. So everybody should have a copy of the wheel, to be honest with you. So I'm ready for questions. If you are, Amanda.
Yeah, please. Everybody has to ask at least one question. Don't you all just go at once now.
Hi, Amanda. It's Cece over at Simple Home Lending.
Hi.
Thank you so much for the presentation. I have a little bit of a statement and then a question. So you're talking about, let's touch back on the feds and the wire, their 5 o'clock cutoff. I would highly recommend to agents to discuss this with clients, because their banks, I know quite a few banks, for example, that their wires, if you don't get in by 2 p.m., they don't go out till the next day. So that 5 p.m., yes, it's for Fed, but it also depends on the bank of when they send their wire as well, which will cause a hiccup as well. So discuss that with a client, because if their cutoff is 2 p.m. and they go in at 3, that wire is not going out till the next day and could delay by a few hours as well. If you have a 10 a.m. closing, for example, even though the lender's funding went through, it could be the clients, the buyers that does not, because their bank actually has an earlier cutoff than the Fed does. So just make sure. So if anybody—
That's a great point. All the more reason to schedule in advance. That's a great point.
It is, just have that open conversation. And then with the lender title, what's the difference between I don't think you touched on it, but the difference between a lender title and then a buyer's title. So if it's a cash deal, which a lot of the agents are doing right now, what's the difference between the two?
Okay,
Is there
that's a
any
great
big,
question. Yep. When you issue an owner's policy, that ensures the buyer. Okay, so that ensures that the buyer has clear title to the subject property. Now, when you issue a lender's policy, that policy ensures the lender's lien position on that property. So when we issue a policy, you know, for a lender for a mortgage and putting their mortgage into first lien position, we are ensuring the lender on the loan policy. The owner's policy ensures the buyer has clear title to the property in their name.
thank you.
Welcome.
I appreciate that you asked that question, Cece, because I think that, and we just talked about this yesterday, Christine and I, we do this every day. We've done this for 50 years put together. We're old ladies, okay? But somebody who is an agent, you don't necessarily know all of the ins and outs of how the policies work, why it's important, and what's being insured. So oftentimes we'll get a purchase agreement from an agent and it's a cash deal and they're representing the buyer. And we call and say, we actually aren't going to be involved because if there's a cash deal, there's only going to be an owner's policy. So there's only going to be one title insurance company involved, right? So one policy, one title company. But we do get it a lot where we have to look at the PA and, say our order entry department is going through it and they say, oh, wait a minute, Sally sent us this purchase agreement, but it looks like she's the selling agent and it's a cash deal. So then that phone call has to be made. And I think it can be confusing. Who's on first? What's actually happening here? So I appreciate that you asked that question. Thank you for breaking the ice. Who's next?
Amanda, I was just going to add to that. I love when you say the three entities that we are mandated by, because I think that always helps too. The lender requirements that we receive from the lender says that we have to have a lender's policy. So that's what we go by. We go by the PA. So that's one, right, entity that we are mandated by. So I love those three things that you always say, because it kind of helps to just that we're not like standing and waiting and can't wait to say no to you. We literally are mandated.
That's what some people think. The way that we're just over here, like, we don't want to close anything. What I like to say is, we can't take creative liberties, right? We are governed by or directed by three documents: the purchase agreement, the title commitment, and the lender's closing instructions. We cannot deviate from those things. So if something very small changes and it seems insignificant and you have your title person asking you for an addendum and you're like, why would I need to do an addendum for that? Because if it says something in the purchase agreement and we're being told to do something different, we need to have that documented. Again, it's not a word of mouth thing. We have to have something in writing, signed, stating directing us how to proceed. Good point, Don. Anybody else? Come on, Sheila. Oh,
you must have saw the question over my head.
I think I did.
Well, I just want you to go through that whole scenario again, because I'm confused on that exact thing, like lender policy versus, and so because we have all these split closings and all this different things, can you kind of go through it so that I can get a better understanding of when I need to order title and who, on what side I need to order title and all that? Because I order title for her, whatever side I'm on. So do I need to do that?
Yeah, great question. And I appreciate you asking it. Also, I'm going to put my number in the chat. Please feel free to call me. Even if you've never worked with us before, or if you use it, we would love for you to use us, but if you use a different title company, you can always still call me any single time you want. And I'm very happy to go through any title topic you want, but I'll try to explain it the simplest way that I know how. If I'm an agent, I'm going to order title with my title company on every single transaction, right? Now, the only time you want to pause and think, do I need to order title, is if you are representing a cash buyer.
Why?
Because on a cash transaction, there's no lender involved, right? There's no mortgage company involved. So if there's no mortgage company involved, then there's no loan policy. So there's only two types of policies, really. We're talking about an owner's policy, which ensures, this is a seller pays for it, and it insures the buyer. It's basically like an insurance policy saying, hey, buyer, you're the only owner, and nobody can come back and say that they have any interest in this property, okay? If you have a cash buyer, they're going to be insured, they're protected by that owner's policy. And 9 times out of 10, probably 9.9 times out of 10, the seller via the listing agent is selecting the title company that's going to issue that owner's policy. So your cash buyer is going to be protected by that owner's policy, but you or your buyer are not the party selecting who's going to issue that policy.
So as a listing agent, and if I do the title work and that other person brings a cash buyer, they don't have to worry about title. Everything's going to be handled on the listing side.
Absolutely correct. Yes.
Okay. All right.
Yep.
I have one other question. Because I just came across this, and I've had experience on both sides. Does the title company order the final water bill? Because I've had it where the title company has, and then I've had to do it. So like is it different for every title company? I mean,
That's a great question. That's a great question. I would say as a general rule, the title insurance company does not order a final water bill. Not to say that it doesn't ever happen. If you're my agent and you call me and say, hey, Amanda, we're closing on this deal tomorrow, would you mind calling the city of Westland and ordering the final water bill? 100%. Every time I'm going to tell you yes. I'm going to immediately hang up. I'm going to call and order that final water bill. If you were to directly ask me to do so, and most title people would probably be willing to do that. What I'll say, and it's sometimes when we're at a closing table, when we get to that water escrow document, okay, says we're holding $300, or which is typically what amount is held. I will say, if the agent's sitting there, has the final water bill been ordered? And then the seller's looking at me like, what are you talking about? And the agent's like, no, I'm going to do it today. I will always kind of present it as that can be ordered by either the listing agent or the seller. So title company typically does not get involved, not to say that we would not be willing to do so.
all right, thank you.
You're welcome. Thank you so much for the questions. I really appreciate you asking. Anybody else? Mark? I love calling people out. I don't know why I do it. Any other questions? Kirk? No?
Awesome.
Carissa? Benjamin? What else we got here? All right. Well, I think we're about 6 minutes from the hour. So if there's any final questions, I would love to hear them.
Yep, and we're always available to answer any of them if you need to get a hold of us. This is recorded and you can revisit it. I'll upload it into our YouTube channel so that everybody can review it again. And these are wonderful because when we do get those questions in, it answers some things that you don't always hear, or it triggers something for somebody else. So thank you for participating and giving us those questions. And we're really happy to help.
Yeah. Also, if you guys have suggestions, or if there's different topics you want to know more about, if there's different title things that you are curious about, or you want to deep dive into how to read a commitment, or you want to go a little bit further into what exactly makes up the closing disclosure, maybe Cece and I can do a collaboration, and Simple Home Lending can give us some really great lender info. But any topics you guys have, or any questions you guys have, we would love to know what, if we do another one of these, which we try to do them kind of regularly. If we do another session, we'd love to know what topics you guys would be interested in hearing some more about. So please feel free to send those ideas over.
Thank you so
I'd like,
much.
I'd like to just you know, because I always try to be proactive. What do you guys have a list of documents that are needed from agents for title? Because it's always like a back and forth thing, like, oh, I need the PA, and oh, I need this, you know, commission, and oh, you know, and it's like a back and forth thing. So do you have a document ahead of time so that I know exactly what I need to send when I'm sending the PA versus,
Yes.
oh, okay, you need this. Oh, okay, you need this
We have
now.
a-
Oh, you need this.
Absolutely, absolutely. We have a couple of different things that we can send you, Sheila. If you, I don't know if we can put our email address or whatever in the chat so we can get a hold of you after, but definitely there's old school, what used to be just called a broker demand. Typically it used to be back in the day, in the 90s and early 2000s, before the crash, we would get a broker demand is what we called it with every PA. And it was basically a 1 or 2 page document that had literally every single piece of information that you already know, right? The commission, the compliance, is there occupancy? Is there a home warranty? What's the HOA contact information? Any number of things. So, you know, one of the people might be passed, or there's a power of attorney being used. So we do have a couple of different documents that you can use for yourself as a checklist, or we have a document that we can send you that you can actually fill out and submit that with your purchase agreement. And that's going to take away some of that back and forth. When you're, like you said, you want to be proactive, if you're providing, a lot of that information with the purchase agreement, that's less that we have to bother you. We don't want to ever have to bother an agent. We know how busy you guys are, but if we get that information in the beginning, that's less of that back and forth, and it makes it for a smoother process. So yeah, we can definitely get you a couple different sources for that.
I did just put our online order form in the chat box too. So if you go to Titleocity.com and click on order here, there's a whole list of things. And if the more that you can fill out, the better. And like Amanda said, we'll have to bug you for a couple things if it's not in there, but that one's a nice, easy, straightforward one to fill out as well.
Thank you, Sarah.
Do you have like a form just so that we can see to see it rather than, when we get in there, then, oh, okay, we need to go and get the, you know what I mean? So ahead of time, we know exactly word for word on a piece of paper what we need to have prepared
I've
for
already
you.
emailed it to you, Sheila. Check your inbox.
Oh, okay, great. Thanks, Don.
Yep. No
Woo,
problem.
that was fast.
Hey, Amanda, did
We've
you
been
want to
chatting.
touch on the EMD forms?
What's that?
Did you want to touch on the EMD forms?
Sure, we can do that. Yeah, absolutely. Earnest money deposit forms seem to be a bit of a bone of contention. Typically what happens is, if we're being, especially like for someone like Sheila who works at EXP, EXP is not holding an earnest money deposit ever, right? So they're always going to be expecting that the title insurance company hold it. We're happy to do so. In order for us to hold an earnest money deposit, we have to have an earnest money agreement signed. And agents hate this. They give us so much pushback, but there's very good reason why we have to have that form signed. In order for us to hold that money, okay, we have to have an agreement on file signed by both parties that tells us what is going to happen with that earnest money if this file never closes, okay? If this transaction never gets to the table, what happens with that money? And the reason why that's important is sometimes the parties disagree on who should be receiving that earnest money. When the parties disagree, nobody wants to sign a mutual release, right? So now we're in a position where we're holding, say, $3,000 of the buyer's money. There's a disagreement about if it should go back to the buyer or if it should go back to the seller. And if we don't have that earnest money agreement signed, we're stuck holding that money for as long as it takes for these people to work it out. And that puts us in a bad position, right? Earnest money, we cannot escheat or send to the state. Sometimes you get those notifications that, hey, you might have some money out there, right? That's because somebody tried to send you a $3 check that you never cashed, and now they have to, quote unquote, escheat that to the state. We are not able to escheat EMD to the state. And without anything signed, we're really just stuck holding the bag, for lack of a better term. So it's a topic we talk about, I think, weekly, but it's that earnest money deposit agreement is very important. A lot of times we get the question of, well, can we sign it at the table? No, because we only need the form when the deal doesn't get to the table, right?
So what does the form say though? I mean, is the form saying that you're not gonna
Nope.
hold it if things go awry?
No, because we have to. If once we're holding it, we're holding it. What the form does is it basically says, if you guys, I'm paraphrasing here, if the buyer and seller don't agree on a mutual release and they are arguing over it should be my money or it should be my money, that earnest money agreement allows us to what we call interplead those funds to the court, right? So we shouldn't be expected to hold this money in perpetuity, right? The document has verbiage in it that says, if you guys aren't coming to an agreement and a certain number of time has passed, we're able to take that money, send it to the court, and you guys go ahead and fight over it in the court, right? Without that form signed, we're stuck just holding the money until there's some kind of resolution.
So in other words, you send it to the court for small claims court or wherever court is gonna fight it out.
Yep.
And versus you holding it and then the court saying to you, it goes to this person.
That is correct, exactly.
Gotcha.
It's basically like we can remove ourselves from that dispute.
Okay.
Right. Yep. Thank you, Patty. That was a great suggestion. Any other questions? Because we're up on the
What I
hour.
did just put in the chat box, we do have this app. It's called Zachem, and it works just like you're depositing a check into your own account. So instead of having to run and go grab an EMD check from a customer, you can have them download the app. They can take a picture of their check and send it right into us without even having to leave their house. So it's pretty cool. It's quick. I mean, I think we timed it one time and it was like under 6 minutes that it got, deposited directly in. So just another side note as something that we can do to help you, expedite, make things easier for you, for your customer. And I can send you something on that too, if you're interested. We have a lot of resources.
Great point. Okay.
If you did that Zachem though, what would happen with the agreements? Would you then just electronically send agreements, the EMD agreements and things like that?
Send it to you that because that one doesn't have to be notarized, we can send that to you and they can sign via DocuSign from wherever they're at as well.
Okay.
Okay, well, we are a little bit after time, so we're gonna let you guys go about your day. Thank you so much for joining us. We'll be on the lookout for another one of these coming up. Maybe we'll do a Title 102 and get a little more in depth if we need to, but thank you so much. Again, we're here to help you. Don't be afraid to reach out, and we will see you soon and hope you have a wonderful day.
Yes, thank you, everybody. Have a great day.
Thanks, everyone.
Stay
Bye-bye.
dry.
Yep.